Well, thank you for being here today. Especially want to thank some folks who are here with me. We have Sheriff King from Palo Alto County. He drove 3 hours to get here today. And we also have Sheriff Sandholt here. He's the Marion County Sheriff. And we have Sheriff Keith Davis here as well from Wayne County. We have Criminal Justice Deputy Susan Crisco, Brittany Sauder, Kate Haberman, and all of us here today to talk about this important issue. We are here today because kids must be protected and abusers must be held accountable. No child should be forced to be stared down by the person who hurt them in court. As a mom and as a prosecutor, I will always fight for victims and I will always stand up for children. Today, we are announcing a constitutional amendment to bring back protections for kids in court. For decades in Iowa, kids and people with intellectual disabilities were protected as they testified in court against the person who hurt them. And then with one ruling, all of those protections vanished. As a county attorney, I know how important this was before I became Attorney General. And as Attorney General, I pledged to work with our prosecutors who are here, our law enforcement, counselors, and advocates to make sure that kids in court are protected. Imagine this. You're a child, you've been hurt, and you finally have the courage to speak up and tell someone. It takes a strong person to speak up, especially when they've been witnessing violence, brutal abuse, or sexual abuse, especially for a kid. It's hard for an adult to testify in court, and it takes a strong person to testify in front of a whole courtroom of people about something sensitive like a parent who hurt them. And now these kids in Iowa are left to fend for themselves. They have to face their abuser in court or decide not to go through as a witness with the prosecution. Now, to put that into perspective, when a child is testifying in court, they're between 6 and 10 feet away from their abuser, just an arm's length away. Imagine testifying in that scenario. It's scary even for an adult, how much more for a child who's been hurt. No victim should be punished for speaking up, and no child should be forced to relive their trauma. I'm going to use an example to illustrate what it was like when children were allowed to testify over a closed circuit television connection. In one Iowa case, there were 2 boys, ages 7 and 9, and they were allowed to testify over closed circuit television. That meant that those boys could sit safely in a separate room as they were asked questions by the attorneys, and the court and jury could see them on TV. They spoke up because their dad had been beating his girlfriend's 2-year-old baby with a belt. He would take the baby upstairs, and the boys would hear the screams and see the bruises around the baby's face and body. Now, that little 2-year-old baby couldn't speak, couldn't testify in court, and the baby's mom was also criminally charged. So prosecutors turned to those 2 boys who were the witnesses. These 2 boys had also been abused by that same father, and they had been removed from him in the past. Their therapist found that the boys could not face their father in court to testify. They were terrified of him because of the trauma. He had abused them for years. And if they had to go to court and just be feet away from him, they would have been too scared to speak, and it would have hurt them even further. Our prosecutors fought for closed circuit testimony for those kids. That way, they didn't have to testify face to face with their father there in the room, but the jury could still hear the testimony. And the judge found that they could testify by closed circuit. That jury convicted the criminal defendant in this case and sent him to prison. But now, with a recent Iowa Supreme Court ruling, that has erased decades of protection for these kids in court. Iowa is the only state in the country that fails to offer closed circuit testimony for these kids. And unless something changes, we will see fewer prosecutions of crimes against children, particularly those that are brutal whether it's brutal beatings and child abuse, or sexual abuse, or other violent crimes that a child might witness. Kids will be too scared to testify, and those cases will get dropped. Criminals will walk free, including those who commit the most heinous crimes, like brutally beating children or child sexual abuse. And worst of all, these kids are left without justice or protection. The court system has to protect children. Our constitutional amendment will fix this problem. It will make it clear that kids can have a closed circuit testimony opportunity if they meet the standards set out in the law. We will bring back closed circuit testimony to protect kids, and we will protect child victims in court, not punish them. We will restore justice. And as a mom and a prosecutor, I will always protect children. Thank you. I'd like to introduce our first speaker who is here with us today. We're going to hear from Susan Crisco. Susan Crisco is the Deputy Attorney General in charge of criminal justice in our office, and she has personally prosecuted a number of cases involving children, both as witnesses and as victims, including many child sex abuse cases. Susan?
Thank you. I'll be brief in my comments. It's important for us to have this amendment, this constitutional amendment. It's important for us to remember that this is not something that we would use in every single case. It is something that is necessary for children that cannot appear in court just feet away from their abusers. The statute that we relied upon in the case that our Attorney General just described was a statute that had been on the books since 1998 and allowed for only certain cases for children to give testimony in closed circuit. That meant that the child had to have a therapist come in and say or testify that that child could not give testimony if this particular accommodation was not given, could not testify. Without that accommodation, those two little boys would not have been able to come in. That was my case. And we would have had to let that man walk and not been able to prosecute that case. That 2-year-old little boy would not have gotten justice. That's how important this particular accommodation is. That is how important it is that we seek this constitutional amendment. Thank you.
Next, we'll hear from Brittany Souter. Brittany is a human trafficking survivor, and she will share with us her story.
Good afternoon. Like she said, my name is Brittany, and I am a survivor of human trafficking. Today, I'm here to shed light on the devastating impact of the recent changes to Iowa's laws regarding how victims of violent and sexual crimes can testify in court. In 2009, I was subpoenaed to testify against one of the men who trafficked me. I had been trafficked when I was just 15 years old, and by the time the call came, I had recently turned 17. That man had beaten me, forced me into situations no child should ever endure, and threatened my life repeatedly. I was paralyzed with fear at the thought of being in the same room as him again. My adopted mom and I made the difficult decision not to go. I couldn't face him. The same fear that he instilled in me to keep me silent while he was trafficking me, kept me from sharing my story in court. I was 17 at the time, and I cannot imagine how much more terrifying that would have been if I had been even younger or in a more fragile mental state. The recent changes to Iowa's law require victims, including children, to sit just feet away from their abusers during their testimony. This is not justice, this is re-traumatization. Survivors already carry the weight of their experiences. Forcing them to confront their abuser face-to-face in a courtroom adds another layer of suffering that could silence them altogether. The amendment is about protecting victims and ensuring that their voices are heard. It is about restoring the system that gave survivors the chance to testify safely without diminishing the defendant's rights to a fair trial. For many victims, the courage to testify is a monumental step. Taking away the protections that help make that step possible will lead to fewer testimonies, fewer convictions, and more criminals walking free. I know how important this amendment is because I've lived the alternative. I didn't testify because the system felt too unsafe for me to do so. How many more survivors will feel the same way? In my opinion, passing this amendment sends a clear message. Iowa stands with its most vulnerable victims, it stands with survivors like me, and it stands for justice. Thank you.
Next, we'll hear from Kate Haberman. Kate is a child therapist who works with children, and she will speak about how difficult it can be for kids to relive their trauma by testifying in court.
As a therapist who has worked for 20 years, primarily with children who have experienced trauma, I have witnessed the intense, automatic terror a child feels when face to face with their abuser. I have sat next to a child who was face to face with their abuser, and this 11-year-old child urinated in her chair. Fear, intimidation, and trauma do that to us subconsciously. Our bodies hold trauma and will respond when reintroduced to stimuli that represents that trauma. Having a child testify about their abuse is hard, but telling their truth, telling details of the most horrific experience is terrifying. And it can be empowering and healing if done in a way that prioritizes their feelings of safety. But having to do that 6 feet away from a person who used intimidation, power, and threats to scare them into submission, to silence them, and to victimize them is putting a child in an unnecessary re-traumatizing situation. Part of how children heal from trauma is by learning and knowing that they have a community of people who will support and protect them. When we expect a child to stand 6 feet away from their abuser in a courtroom filled with grown-ups in uniforms, grown-ups who are in positions of authority and represent community safety, and we insist that that child be face-to-face with the person who abused them, intimidated them, scared them, filled them with shame and doubt, we are re-traumatizing them. We are re-exposing them, watching them stand alone and re-experience fear and humiliation. And now we are adding another layer of trauma by creating a space where the child is actively experiencing this trauma again and feeling as if no one, the courtroom filled with adults, is helping them. Because of how trauma affects the brain and body, it is likely their bodies and minds will freeze out of fear, and their ability to access their logic and their memory will be limited. This will hinder their ability to offer their testimony, resulting in the possibility of the abuser going free. We, as the adults, the ones in authority, the ones we want our children to trust and feel protected by, are insisting that that child once again compromise their own feelings of safety, integrity, humility, shame, embarrassment, and fear for the benefit of the accused. We are misusing an opportunity to empower this child, to teach them that their world is a safe and supportive place. This is unnecessarily exposing them to the very thing we as a justice system are committed to protecting them from. Let's offer them an opportunity using closed-circuit testimony to not only be heard, but to have an experience that allows them to be heard in a way that also allows for healing, safety, and empowerment.
We appreciate the support of law enforcement all across the state for this important constitutional amendment. We have here with us today Wayne County Sheriff Keith Davis, who is the president of the Iowa State Sheriffs and Deputies Association, and thank him for our partnership with law enforcement and the commitment of law enforcement to protect victims, especially kids.
Yes, thank you. Like Attorney General Brenna Bird said, I'm Keith Davis, Wayne County Sheriff. I just recently became the president of the Iowa State Sheriffs and Deputies Association, and we stand completely behind this initiative to have the amendment in the Constitution to protect our children and those most vulnerable. It's hard enough to get people to come forward, and especially a 5-year-old or 10-year-old when they've been a victim of violence, sex abuse, and even in our small county, we see plenty of that. And it's hard enough to get adults up there to face their accuser or face the person that abused them. So we will do everything we can to support this. I'm also on the legislative committee for the Iowa State Sheriffs and Deputies Association. We completely back this amendment. It's the right thing to do, and it's sad that we have to do this because the decision that was made last summer should not have been made that way. We need to protect our victims. So thank you.
Thank you. Next, we'll hear from Dallas County Attorney Matt Schultz. Matt will talk about our shared commitment to serving families and supporting kids throughout the court process.
Well, I want to first thank Attorney General Bird for the opportunity to come before you and speak today. I can't tell you how disappointed I am in the outcome of the court decision from this summer. You know, this isn't an academic problem. This is a real problem. And as a prosecutor, I've had the opportunity to sit and work with children who have been abused sexually and who have been the victims of violent crimes. You know, our government is here to protect us and protect those who are most vulnerable. And there's nobody more vulnerable than little children. And I can't tell you how difficult it is for them to sit in the same room with the person who assaulted them. These are real crimes and demand a real solution and a real answer. And if the institutions of our government won't protect those who are most vulnerable, our children, then it's up to us as a people. And so I want to thank Attorney General Bird for her leadership on this issue, for leading the charge and getting a constitutional amendment before the legislature so that we can get this on the ballot, so that we as a people can send a strong message that we are going to protect the children and those who are most vulnerable in our state and in our communities. Thank you, Attorney General Bird, and thank you for letting me be here today.
Thank you. And we appreciate the support of prosecutors all across the state for protecting kids in court. Next, we'll hear from Lynn County Attorney Nick Maybanks. He will talk about the necessity of closed circuit testimonies and how they help secure successful prosecutions of criminals. Nick.
Good afternoon, everybody. My name's Nick Maybanks. I'm the Lynn County Attorney. I'd like to also thank Attorney General Brenna Bird for the invitation to be here today and commend her for standing up on behalf of children, victims, and vulnerable victims in this state, and also taking the initiative on this proposal regarding this important constitutional amendment. Throughout my 24 years as a criminal prosecutor, I've guided countless children through the criminal justice system. I want to tell you a brief story about a 13-year-old victim in a case I recently prosecuted. And I'll refer to her by her first initial, A. A lived a childhood like many other girls. She had a lot of friends, siblings, pets. She did well in school. Her parents were divorced, so she split time between her mom and her dad since she was about 8 years old. She had a normal childhood if you were looking at it from the outside in. But she also held a secret that no kid should ever have to hold. You see, during her childhood, when she would have visitations with her father and he would drink too much, he molested her. She held on to that secret for years. She didn't tell anybody. But she became worried about her younger siblings. She didn't want to happen to them what happened to her. So she told her secret. And when I met her for the first time after we charged her father with sexual abuse, she was visibly trembling, shaking, and terrified. Not only about having to tell complete strangers what happened to her, but having to do it in the presence of her father. She was hospitalized numerous times during the pendency of the prosecution for suicidal thoughts and self-harming. She was in counseling, but she couldn't even talk to her counselor fully about what happened to her. What had happened to her at the hands of her dad was psychologically devastating. Without the ability to utilize reasonable alternatives to face-to-face confrontation, we would have no choice but to put A on the stand in front of her dad. Instead of having reasonable alternatives to face-to-face confrontation, we had the choice to either compel A to testify in front of her dad and risk further psychological damage or other unspeakable outcomes, or let the defendant off with no consequences. This is not a dilemma we believe the Constitution should require. Although we respect the decision of the Iowa Supreme Court and their authority to be able to interpret the Iowa Constitution, we also have a choice as the people in the state of Iowa. And that choice is to enact a constitutional amendment to protect victims like A. With this proposed constitutional amendment, Iowans will get a rare opportunity to have a voice in the framing of their own constitution, to speak for our values as a state. Iowans will get a chance to make it clear that when it comes to the sacred right of confrontation, we acknowledge that right, but also acknowledge that there may be vulnerable victims like children who need our protection as well. Iowans will have an opportunity to allow lawmakers through the democratic process to determine reasonable alternatives to face-to-face confrontation when circumstances such as those facing A may require it. So I stand here today as the elected county attorney of the people of Linn County, a prosecutor with over 24 years of experience, and a voice for all of the A's out there, like these people behind me are as well, in full support of this constitutional amendment that Iowa needs. I look forward to its passage, and I'm grateful to be here with the Attorney General and all these fine people up here today who spoke to you to offer my full support. Thank you.
Thank you, Nick. And just appreciate the support for this constitutional amendment from law enforcement, from advocates for children, and from prosecutors all across the state. At this point, we'll open it up for questions related to this subject matter.
The four justices who joined this majority opinion were conservatives, appointed by a conservative governor, and they were taking this originalist approach, drawing on criminal prosecutions from the 19th century. Do you feel that they reached the correct conclusion, but that this amendment is necessary for public policy reasons, or do you feel that this case shows the limits of originalism as a way of interpreting Iowa's Constitution and that they still got it wrong?
I believe, I do not agree with the Iowa Supreme Court's decision in this matter. I do respect it and respect the court. That is why we have introduced a constitutional amendment that will solve this problem. We are the only state in the entire United States that doesn't allow this. And the United States Supreme Court opinion is from the 90s that allows children to testify outside the presence of the person who hurt them or the criminal defendant. That has long-standing. It's been around for a long time. We're the only state that has a decision like this. So I don't think that this has much to do with originalism as a legal matter. Instead, I think it's important that we make it very clear and that we amend the Iowa Constitution to protect children.
With the current Supreme Court decision in place, have there been a lot of people trying to get their convictions overturned on that, or what's going on basically in the court right now?
Well, the fact that we have this ruling from over the summer in June makes it very difficult. And it makes it difficult for children victims and their families as well. That's another reason why we need this Supreme Court to have this amendment, this constitutional amendment that can make it very clear that under Iowa law, if certain aspects are met, as the legislature decides, that children can testify outside the presence of their abuser. And it's not something that every child needs, but it's something that some children need in order to get justice. Yep. Did you want to say anything about that? No. Okay. Because the way that the Iowa Supreme Court made their ruling, they decided it based on the Constitution's Confrontation Clause. And to make it clear that the Iowa Constitution allows children to be protected in court and testify outside the presence of their abuser, this constitutional amendment will solve that problem, will fix it.
The legislature has the authority to have a special election for proposed constitutional amendment. They've done that a couple times, but the earliest this could be considered, if the legislature advances it, is 2027. What happens in the interim for these cases? Will they be kicked up to federal prosecution, or are we considering other alternatives?
Well, to be clear, we will do everything we can to protect children here in this state. And we are proposing this constitutional amendment. It will take time. In the meantime, we will do everything we can to protect children and to help them through the court process. But the reason we need this amendment is because some children aren't able to testify in front of the person who hurt them. And so in those cases, those victims will not get justice and those criminal defendants will not be held accountable. But as prosecutors and as law enforcement, we work together and we will do everything we can to protect these kids. But we need this constitutional amendment so that we can help them.
I was going to just follow up on that really briefly here too. And so as a prosecutor in Linn County, the second most populous county in Iowa, this ruling will not stop us at all. We're going to go forward with our cases. We don't need to rely on the federal authorities unless they have jurisdiction and they want to do it with us. So we just plan on helping our kids the best we can, but look forward to that day when we can have the legislature set the rules for that testimony and move forward.
Let me say a little bit about that. The ruling decided that one case, and it was a little confusing. Something that every prosecutor, for example, of a case involving a child who's been sexually abused will think about. They will want to make sure that the evidence and testimony is presented in a way so that that child doesn't have the case go up through the appeals system and come back and have to be retried again, where they have to go through two different jury trials. So the lack of clarity in the opinion is a further problem because no one wants to have a conviction against a sexual abuser, child molester thrown out on a technicality. And that's one of the things that prosecutors all across the state, like Mr. Maybanks, are working through with their cases. The language is fully drafted, and what it does is it returns it to the way things were before the Iowa Supreme Court decision in June.
Does it use the phrase closed circuit, or does it use some other phrase that in future technology advances, there may be some other way of describing that process?
Constitutional amendments are written in a way so that they can stand the test of time. And we have written this amendment to protect children over time. The legislature has the power to provide specifics as to how that process works. And that's done through Iowa Code, just the way that it is currently being done. Any other questions?
Just one. You talked about protecting children in the interim through this long process ahead. Exactly what would those protections look like? What can you do?
Well, we will do everything we can to work with kids to make sure they have advocates and counselors like Kate here, and we will help them prepare for court. We know, though, that we need this constitutional amendment to fully protect children, and we will continue to seek that and continue to work for that. I just want to make it clear that particularly the prosecutors here today and all across the state are fully committed to prosecuting these cases and helping to serve child victims under the law. We just need a constitutional amendment to make it clear that kids can be protected in court. Thank you.